Good afternoon, everyone. This is Pam Mazza. I'm with John Williams, and welcome to our webinar to discuss the SBA's proposed rules on the Mentor-Protégé programs and to discuss the limitations on subcontracting proposed rule. Thank you all very much for joining us. We will be focusing on the Mentor-Protégé program primarily because we had a webinar a couple months ago on the limitations on subcontracting, and so please feel free to get on the website and re-listen or listen for the first time to that if you need any more information on the limitations on subcontracting. Yesterday we were very pleased to do a seminar here around the Beltway at the Tower Club with John Klein, who is probably the chief drafter of both of these proposed rules, and we were able to gain some additional insight from that webinar, that seminar, on what the SBA intends and what they would like to see. So we're going to try to sprinkle as much of that information in here as possible. Also, just at the outset, the SBA intends to extend the due date for comments on the Mentor-Protégé programs, and so the new due date will likely be May 6th rather than April 6th. They're looking at a 30-day extension, so that takes a little pressure off on the due date for that one. The limitations on subcontracting rule has already been extended, so those comments are due on Monday. And if you would like to see our comments, we can send our draft around after this call, and please feel free to pick anything that you think is applicable to your firm and to send in comments on the limitation on subcontracting rule by Monday. So let's get started with an overview. As I said, we'll talk about these two rules, Mentor-Protégé first, and in those rules, if you haven't had an opportunity to look at them, there are some other items in those rules that are also very important pertaining to joint ventures, the 8A program, hub zone, affiliation, and size recertification, to name a few. So as we said, this proposed rule for mentor-protege programs was, the genesis was the 2010 Jobs Act, where Congress said, we like the 8A mentor-protege program. SBA, we would like you to duplicate that for hub zone, women-owned small businesses, and service-disabled veterans. And then in the National Defense Authorization Act of 2013, Congress extended that to all small businesses, and interestingly, that law says that it shall be identical to the 8A Mentor-Protégé program. So it gave a little more clarity on its intent.
Sure, yeah, and I'll just add, yesterday John Klein from SBA confirmed that the SBA is looking at an extension of that comment deadline, so it was listed on the prior slide as April 6th. So right now comments are due for both rules on April 6th, but we're anticipating an extension for the mentor-protege rule. So as Pam mentioned before, just to make sure we're clear, limitations on subcontracting rule comments are due Monday the 6th. Mentor-protege rule comments are likely to be extended into May. And John Klein said yesterday he thought they could get the final mentor-protege rules out by the end of the year, but it'll depend in part on how many comments they get. So let's dive into the mentor-protege rules then. What the primary purpose of this rulemaking is to create a new mentor-protege program, and the SBA has decided to create one new program that would be available to all small businesses. They considered 5 different mentor-protege programs, a separate program for each of the types of small businesses, but they think that's not as workable. It's likely to lead to confusion, and so they've decided to go with the one program for all small businesses, and that makes sense to us. I think we agree that 5 programs would be unwieldy and likely to cause confusion. And as Pam mentioned before, they're patterning this new program on the 8A Mentor-Protege program. So if you're familiar with the 8A Mentor-Protege program, then you have an idea of what types of benefits and assistance the new small business mentor-protege program is going to provide. It's intended to be a business development tool. The mentors will be able to provide financial, technical, and management assistance. Importantly, for many of you listening, the new program would allow small business proteges to joint venture with their large business mentors and to go after any set-aside project that the protege is eligible for. So if the protege is a woman-owned, service-disabled, veteran-owned small business, the mentor and protege could go after small business contracts, SDVOSB contracts, or WOSB contracts through a joint venture. Like the current 8A mentor-protege program, the new small business mentor-protege program would allow mentors to own up to 40% of the protege. And other forms of assistance envisioned include loans, financing, prime contracts, and subcontracts, although we would like to comment on the subcontracting piece of this just to make sure it's clear, because there has been in the past some confusion about whether the 8A mentor-protege program envisions the protege as a subcontractor.
And also that there's been some confusion, and there's been an SBA Office of Hearings and Appeals decision that says that the purpose of the program is for mentors to provide subcontracting opportunities to proteges, not the reverse. And in fact, SBA intends for small businesses to be able to subcontract to their mentors. And while you can find affiliation for other purposes, if it is included in the mentor-protege application and the mentor-protege agreement, then that type of assistance should have the exemption from affiliation. So we're going to suggest that they put some stronger language in this rule to clarify that.
Mm-hmm. Yeah, and that's a good segue for me to just add that we're formulating our comments on this, but we really would like to get feedback from all of you. So you can do that today during the webinar by posting questions, and we have a few that are posted already, and we'll answer as many as we can later today, or we'll follow up afterwards as needed. But also post your comments or email us after the fact, and as you hear us describing where we think we need to comment and try to help shape the final rule, if you agree or disagree, please let us know. We want to know. And the slides will be available after the presentation. They'll be on our website along with the audio, and I believe they will also be emailed to everybody who signed up. All right, so let's talk about protege eligibility. The SBA is doing some interesting things here, and according to their proposals, they are changing the criteria in one respect to make it a little bit easier than it is right now to qualify as a protege for the 8A program, because right now you have to fall into one of a few buckets in terms of your where you are in the 8A program. And because obviously the rest of the small businesses won't be in the 8A program, the SBA is going with a more simple requirement that the protege simply needs to be a small business and in need of mentoring. But interestingly, the SBA is proposing that the applicant has to be a small business in its primary NAICS code. And we had some good back and forth with John Klein yesterday on that, and I think the SBA is open to comments on whether that makes sense, because if you require a small business to be small in its primary NAICS code, then you're restricting their ability to seek a mentor-protege relationship in a secondary industry. You know, once you outgrow your primary code, you wouldn't be eligible to seek mentoring in another area, and that in fact is maybe the very reason you would want mentoring in another area. So we're going to comment to the SBA that they ought to just require the protege to be a small business in whatever NAICS code it is seeking mentoring in. SBA is also proposing that a protege, in order to qualify, undergo a size determination, formal size determination, and that would be potentially a brand new size determination proceeding. If you've already undergone a size determination, the SBA will let you certify that there have been no changes since the prior size determination. That seems unfair to us, that some firms would get to essentially self-certify that a prior size determination is still okay, but other firms that just haven't undergone a size determination would have to go through what is likely to be a fairly time-consuming and potentially expensive process. So it's going to give certain firms, we think, maybe an unfair advantage at the application stage, and we're going to suggest SBA ought to just focus on self-certifications from all firms as opposed to only some proteges. Pam, you probably want to comment on the next item. The SBA is how they're going to view existing mentor-protege relationships from other mentor-protege programs.
Okay, and is there a slide on that too next?
No, it's
okay.
Yeah. Maybe
SBA, along with the application, the protege will be required to identify whether or not it is a protege in any other agency mentor-protege programs. And because there are limitations on the number of mentor-protege agreements you can have at one time, that could impact your eligibility to participate under SBA's program. And as John said, and there is a slide coming up, but I'll just jump to that now, the SBA, as part of this proposal, is saying that, you know, it will only recognize the DoD program because that is a statutory program, but it's giving the other agencies a year to submit their programs to SBA so that SBA can review them and determine whether or not there's a need for those programs on an ongoing basis, or whether now this new mentor-protege program is adequate. And SBA is asking for comments on that because they recognize that some of the programs may have special abilities or special circumstances that aren't covered by the SBA's program. Of course, none of the other programs have the ability for a mentor to make a financial investment in the company with ownership of up to 40%. So this program stands out as potentially having an additional financial benefit to all of the proteges that participate. And the other programs do not allow for joint venturing with large mentors, but this program does. So I think SBA is thinking that their program will be rather wholesome and kind of a soup to nuts program, and that maybe some of the other mentor-protege programs are unnecessary because they will be either duplicative or not as robust. But we're aware of a couple of programs that do have special circumstances that stand out that really probably could remain in place even with the existence of this program.
Mm-hmm. So I'll flip to the next slide, which talks about mentor eligibility, but the last point on the protege eligibility slide says SBA is proposing generally you would have no more than one mentor, although you could possibly have up to 2 mentors as a protege. And conversely, as a mentor, they're proposing that generally you would have no more than 1 protege at a time, but maybe you could have up to 3 proteges. And we'd like to get your views on how you feel about the numerical limitation of mentors and proteges. To me, I think we ought to push the SBA to move away from what I might argue are arbitrary numerical restrictions and focus instead on a holistic assessment of can this protege benefit from mentoring from a second or a third mentor? Can the mentor impart real value and help the growth of 3 or 4 or 5 proteges? I would think in some instances the answer would be yes. In some cases the answer would be no. And that assessment is what should drive how many mentors or proteges a company can have, as opposed to a bright line numerical restriction. And I think the sense that I got yesterday was that the SBA may be open to changing the number, but I'm not sure if they'll move away from a numerical restriction. So we may be able to increase the number, but I don't know if we'll be able to do away with that requirement entirely.
SBA is very concerned, and I see some comments from our audience today reflecting the same concern, that they want to be sure that the proteges are benefiting, and while they recognize that, you know, things like an ownership interest for the mentor and the ability to joint venture on small business set-asides are kind of the carrots that they hold out to encourage these large businesses to provide assistance, they don't want large businesses to overly benefit from the small business programs. So it seems as though they're trying to balance the benefits to the proteges against the, you know, possibility or the political fallout that they might get from it appearing that large businesses are benefiting from these small business set-asides. So I think that that's what they'll struggle with, and I agree with John. The number, it may be that it's more than 3, but it may be that it's going to be a definitive number. One thing that I think that we would encourage comments on as well is that they consider, for example, Northrop Grumman to be one company, whereas Northrop Grumman has multiple divisions. A lot of large businesses do in different areas of expertise. And so a question is, should we file comments to suggest that it should be you know, somehow broken down or defined differently as to who the protege is? Maybe the protege is, or who the mentor is. Maybe the mentor is the Northrop Grumman IT division or the Northrop Grumman manufacturing division, and that each of those would be viewed as separate mentors. There are a lot of small businesses in the database out there that seem as though they would be able to benefit from mentors, and so again, if you're restricting a mentor to no more than 3 proteges at a time, it could possibly limit the number of proteges that are available. SBA is also struggling, by the way, with how they're going to process all these applications, so I think that there's that thread of concern weaved through these regulations.
Mm-hmm. And we got a question about the last bullet on this page. A protege cannot also be a mentor. That is the proposal right now. The SBA's proposal is that if you're a protege, you can also be a mentor. But the impression that we got yesterday is that they're very open to comments on that. And I think there is a very reasonable comment that, again, to go back to the holistic assessment, there will be some cases where a protege is also capable of being a mentoring, and why wouldn't we want to foster that if they're willing and able to fill that role while also receiving assistance as a protege.
So I'm getting a question as to whether or not DOD will recognize and accept SBA mentor-protege agreements within DOD. And we got that question yesterday, and I was a little surprised by it. I mean, the DOD mentor-protege program is separate and apart from any other mentor-protege program, and it's one of those programs that definitely has different benefits because they will reimburse proteges under some circumstances for the expenses of they'll reimburse mentors for mentoring. And they also allow for the dollars subcontracted to the proteges to count toward the subcontracting goals as well as the assistance provided. So, however, that program, and it does have an exemption from affiliation, but I think that the way I responded yesterday was that if you are, let's say, a joint venture with your SBA-approved mentor and you compete on a DOD contract, you're awarded that contract as an approved mentor-protege joint venture, and someone protests it, that would be a size protest, and that would automatically go to SBA. So SBA would review that joint venture agreement and determine whether or not it's compliant with SBA rules, and then determine whether or not that joint venture is small. So I'm not sure, unless you see a solicitation where DOD says they're not recognizing an SBA mentor-protege relationship, I'm not sure that DOD would care. But if anyone knows any more about this, if you could let us know, because we probably would need to comment on it as well.
So the next slide we have up here is how to apply to the Mentor-Protégé program, and the two key takeaways here, I think, are one, that they're proposing to keep the 8A office for processing 8A Mentor-Protégé programs and have the separate Office of Government Contracting process all the other Mentor-Protégé applications. They're asking for comment on whether it makes more sense to consolidate the review of all Mentor-Protégé applications into one office for sake of consistency. And while I do think it makes sense from the standpoint of consistency, there's a legitimate concern about one office's ability to handle the volume of applications that SBA may get. And I think SBA rightfully is unsure and concerned about that too. So I think we favor the two offices at this point. And the other key takeaway from this page is the SBA's proposal to have open and closed application periods. And again, this goes to the concern of whether they'll be able to handle the caseload when all the applications start rolling in. And it's understandable why they might propose this, but we're not in favor of it. I don't think it worked well for the VA's Mentor-Protégé program because it was closed more often than it was open, seemingly. And there's a fairness issue, I think, in terms of some firms will be able to get in during the open period, and other firms will be shut out, and it may not be clear when they'll be able to get in. And even if it takes a long time to process an application, everybody would at least be on the same foot in terms of being able to submit the application when they're ready, if it's always open. And SBA want everyone's comments on this issue, so that's an important issue to make sure you get your voice heard.
So in terms of the participation period, the SBA is proposing to essentially limit the protege's participation period to a total of 6 years, and that can be divided up with 2 3-year agreements with either 1 or 2 proteges. If it's with the same mentor, then obviously you would have an agreement with your mentor for 3 years and then a second agreement with the same mentor for 3 years, but you could also have an agreement with 2 mentors either concurrently or one after the other for 2 3-year periods. And the SBA is saying that it will review these agreements annually. Again, we're not sure that that's necessary, or also that they will be able to keep up with that. So I think we're probably going to comment on that as well, that maybe annual reviews aren't necessary. And SBA is also proposing that the mentors can only be for-profit firms. And in the 8A program, the SBA allows nonprofits to be mentors. And SBA is taking the statutory language and saying that it prohibits nonprofits from being mentors under this new program, and so it's proposing to eliminate the nonprofits from the 8A program as well. I don't know whether that impacts folks on the phone, but we think that there's an argument that nonprofits could be permitted under the statutory language to be mentors, and we'll be commenting on that.
Yeah, I think Pam mentioned, but we've heard from folks already that it's hard to get a mentor-protege arrangement really up and running within a few years. It takes that long just for the companies to get to know each other and figure out how to take full advantage of it. So, our concern is that the current approach to the limitation on how long you can be in the program effectively limits a protege to having only one mentor if you really want to make the most out of the program. So I think the SBA seemed open to changing these limitations, and so we ought to put our comments in on that.
And we have a couple of good questions that I think I can answer quickly. One is whether or not, how it works if one protege has more than one socioeconomic designation. And if you are in the 8A program, you can be a protege in the 8A program, or you can be a protege in the new program. If you're in any other socioeconomic class, you can be a protege in the new program, and that enables you to go after, well, in either case, it enables you to go after contracts, whether as a joint venture or as a prime sub with your mentor, under any set-aside program, so long as you, the protege, are eligible. So if you are in the small business program, you and your mentor can go after a hub zone set-aside if you're a hub zone company. If you're a WOSB as well, you can go after a WOSB set-aside with your mentor. So they're trying, with a couple of distinctions that remain in the 8A program, they're trying to put all of these programs in parity with each other. And the question is, how does the time frame of the agreement relate to outstanding proposals? They are not proposing any change to the 3 and 2 rules. So the 3 and 2 rule says that if you are eligible at the time you submit your proposal, including price, then you are able to receive that award even if your mentor-protege agreement has expired. So the rule is that you can win up to 3 contracts and then you must stop bidding, or you must stop bidding 2 years from receipt of the first award.
And we got a question about whether SBA is open to eliminating the term limits, and I think I answered that. But yeah, I don't know if they're open to eliminating it entirely, but I think they're at least open to extending it. I'd like to see them, and I guess I'm a dead horse at this point, I'd like to see them focus instead on whether the company still needs the assistance. And if it's a small business and still in need of assistance, I'm not sure why we need to limit it to a certain number of years. But the clock would start ticking for your term when you get approved into the mentor-protege program. The next slide coming up, Pam alluded to this earlier, that there's debate and SBA seeking comment on how this new mentor-protege program would impact other mentor-protege programs. I'm not sure if I need to add anything here other than the SBA's view seems to be that to question the utility of these other mentor-protege programs, with maybe 1 or 2 exceptions, those programs that Pam mentioned, like DODs that have specific unique forms of assistance or benefits that we would not find in the SBA's program. But others, like in particular the VA's Mentor-Protégé program, the SBA is seeking comment on whether the VA should continue to have a Mentor-Protégé program after the SBA's is up and running, I think with the clear implication that they don't think it's necessary. So they're looking for comment on that.
In answer to another question, we tried to visit yesterday the question of whether or not subcontracts count toward the 3 and 2 rule, and I think that SBA is thinking about that. So we didn't get an answer, and I think that we're probably going to try to get something in the regulations that clarify that question. So moving to joint ventures, as we said, under the 8A program, mentors and proteges are permitted to joint venture to go after small business set-asides and 8A set-asides, and that would be the same rule for the new program. SBA is proposing to clarify what their intent is, and there's a lot of talk about informal versus formal joint ventures, and SBA is saying that you can have either. But what SBA means by an informal joint venture is really simply that you don't need to form an LLC. If you're a joint venture, that joint venture takes on a new entity anyway. You need to have a new EIN number, a new bank account. You need to register that joint venture in SAM. So whether they call it a separate legal entity or not, it really is. It's simply a limited purpose entity that only exists until it can't exist anymore under the regulations because you've done your 3 and 2 and your contracts are over. So we're going to suggest that SBA eliminate this informal versus formal and simply say you have two choices. You can do a joint venture, which under most state law would be treated as a partnership, or you can do an LLC, but it needs to be one or the other. SBA's main interest is in being sure that you have a written agreement that complies with the regulations. SBA is also proposing to eliminate populated joint ventures. And again, they're asking for comments on that because they are not seeing the benefits of a populated joint venture for the proteges because they're not, the protege itself is not performing work as a subcontractor to the joint venture, and so SBA is asking for comments on what the utility of that populated joint venture would be and how that would benefit the protege. SBA, again, and I think this is probably from the SBA Inspector General's office, is requiring annual certifications of compliance from the joint ventures, and we asked whether that compliance certification would come from the mentor or the protege, and it sounds like it would come from both. So you would be certifying compliance with the performance of work requirements and with the other components of your joint venture agreement. SBA is also asking for comments on the best way to track joint venture awards and I guess revenues going to these joint ventures under these programs, because they can track the 8A joint ventures, but the question is, how will they track the rest?
And to answer one of the questions we have posed on here, Pam said they're proposing to eliminate populated joint ventures, but the rule is written to say that that would only be for formal joint ventures. And what we learned yesterday is that's probably just an oversight in the drafting, that they didn't intend to keep populated joint ventures for informal joint ventures. So we'll make that comment, and we anticipate in the final rule it'll just simply eliminate populated joint ventures for any type of a joint venture.
So another important portion of this proposed rule is for hub zone companies. Currently, hub zone companies can only joint venture with other hub zone companies. And SBA is proposing that hub zone companies may now joint venture with non-hub zone companies, including their mentors. And so they've asked for comments on that. But again, I think in an effort to be uniform, that's what they're proposing. Under existing 8A rules, the 8A company must perform at least 40% of the work of the joint venture, and then the 8A company and its joint venture partner must satisfy the limitation on subcontracting rule. So if it's a service contract, the joint venture must perform 50% of the work, and then the 8A company must do 40% of the 50% of the work. We suspect that the new limitation on subcontracting rule, when it becomes final, will be applicable to this program as well. Size protests are permitted to challenge these joint ventures, and size protests will also be permitted to challenge 8A joint ventures.
Yeah, and that's a departure from the last few years. We were involved with the case a few years ago where OHA said you can't challenge an 8A joint venture in a size protest because the SBA has already approved the joint venture. So if a different SBA office has already approved the joint venture, we don't want a separate SBA office looking at it again and potentially reaching a different conclusion. And the SBA is now saying, well, when we approve an 8A joint venture, that doesn't mean we've made a size determination about the joint venture. So we're going to permit size protests. And we just want to make clear in the final rule that they're not permitting protests regarding compliance with the various joint venture rules or mentor-protege rules, that it's strictly about the size of the parties in the joint venture and whether the joint venture meets the size requirement for the contract. So Pam mentioned, there are a lot of similarities between the current 8A joint venture rules and what the SBA is proposing for the new programs. There are some differences, though, and I saw a question about this a few questions ago, so I think we'll address it here. The SBA has proposed for joint venture partners to share profit commensurate with their ownership interests when the joint venture is a separate legal entity. And when we brought that up yesterday, John Klein indicated he thought it was just simply a drafting mistake, that they intended for profit to be shared commensurate with the work performed by both parties in the joint venture. So we're going to comment on that and anticipate it gets cleaned up in the final rule. Yeah, they also need to clean up and harmonize between this rule and the limitations on subcontracting rule in terms of how we determine the size of the joint venture, because right now the size of the joint venture, it's either going to be that both, and this is not for mentor-protege, I'm talking now about joint ventures involving multiple small businesses. Right now the rules say that it depends on the size of the procurement whether both joint venture partners have to be small on their own, or in the aggregate, the joint venture partners have to be small. And like I said, it depends on the size of the procurement, which way that goes. In the limitations on subcontracting rulemaking, the SBA has proposed to eliminate that and just simply say that in all cases, regardless of the size of the procurement, size of the joint venture will be based on the individual size of the joint venture partners. So as long as both joint venture partners are small on their own, the JV would be small. The SBA didn't include that same language in this mentor-protege rule, so we just need to harmonize it. We like the way it's proposed in the limitations on subcontracting.
And we're also going to put a comment in to ask for clarification in the size regulations, because the size regulations say that for purposes of determining whether the small business is small, that the percentage of ownership, that the proportionate share of revenues is based upon the percentage of ownership in the joint venture. So the small business will have to own 51% of the joint venture, but if they're only doing 40% of the work, really 40% of those revenues should count to determine whether or not that small business is small. And I think there was agreement on that. The regulations just aren't clear. So we'll be asking for clarification on that. And there's a question about past performance, John, and we were talking about that yesterday.
Yeah, that's a great question. There's a question here about whether, because we're trending towards unpopulated joint ventures now, and we may end up with, that's the only type of joint venture. How do we deal with the trend amongst some agencies where they're requiring the JV itself to have past performance and they're refusing to look at the past performance of the individual JV partners? The proposed rule doesn't address that. And we, to the extent that the SBA could address that in the regulations, we may want to comment on that. But there was some legislation recently put through the House Small Business Committee, I think just within the last week, and that we're hoping will get into the NDAA this year. And that legislation says explicitly that agencies shall consider the past performance of joint venture partners when the joint venture itself doesn't have past performance. So that legislative fix will not be an immediate solution for the problem, but at least it seems to be on the horizon. Okay, so now we'll move into the last section of the mentor-protege rules, deal with the 8A program. There are several proposals for the 8A program, and the one I think that we spent the most time on yesterday, and the one where we'd like to get a lot of comments from you folks on, pertains to what the SBA is proposing to do to change how it reviews an 8A applicant's claim of social disadvantage. The SBA has lost a few cases at the Office of Hearings and Appeals recently where they denied an applicant because they didn't think the applicant had provided enough evidence to prove that he or she had faced social disadvantage. And the judge at the Office of Hearings and Appeals overturned the SBA's decision, finding that the SBA was holding the applicant to too high of a burden of proof, and because it's supposed to be a preponderance of the evidence standard. And so, to address this and from our perspective make it easier to deny applications, this new rule would permit the SBA to disregard an applicant's claim of social disadvantage if the SBA believes that the applicant did not provide sufficient evidence to make his or her claim any more likely than a legitimate alternate reason for the adversity. So the example that we talked about yesterday was a female applicant claiming that she did not make as much money or did not receive a promotion that was given to a male counterpart. And the SBA's perspective on this is that there are a lot of reasons why the male may have received more money or received the promotion. And if the applicant doesn't provide evidence to support the fact that it was because of discrimination that the female didn't get the promotion or additional money, then the SBA wants to be able to deny the application, basically. And the real challenge with that is, of course, that discrimination very often can't be proven through a nice smoking gun document. You're not likely to get the person who committed the discrimination to explicitly tell you they were discriminating against you. And we're just concerned this creates a slippery slope for the application process and make it to hold applicants to a higher burden than they're supposed to face.
And just one point of clarification, this rule change would only be applicable if you're not a member of a designated group. So the non-minority females, the service-disabled veterans, and others such as that who try to apply to the 8A program have a higher level of proof currently, and our concern is that this makes it even higher. Now, these next couple of changes I think are important. This one in particular, it says that the SBA would have the discretion to change an 8A program participant's primary NAICS code based on a plurality of the firm's revenues over the most recent 3 years. And I think what this may lead to is a firm that has a NAICS code that is high and makes them eligible to remain in the 8A program. If SBA decides to do an analysis of the contracts that that firm has, and if a plurality of those contracts are in a different NAICS code that makes them other than small, and SBA changes the primary code, that could serve as a basis for graduation. I believe, though, that what they're trying to address here is the tribal ANCNHOs who may have multiple 8A companies so long as they are not in the same primary NAICS code. So what this proposed rule suggests to me is that SBA will be drilling down on and monitoring what activity each of those tribal 8As has and determining whether or not two or more are really functioning in the same primary NAICS code, and if so, it will commence graduation proceedings, or one or more of those 8As will have to withdraw from the program. But it potentially impacts all 8A program participants, not just the tribes. In addition, SBA is proposing to allow firms to suspend their program participation if, for some reason, there is a lapse in federal appropriations, or if they're located in a declared major disaster area. We had a lot of companies that were really wiped out and had to take a step back during Katrina, but there was no ability for SBA to sort of suspend them from the 8A program until they got back on their feet and then pay back the time. So this provision addresses that. Likewise, when we had the government shutdown last year, there were a couple of firms that had contracts pending, and in the 8A program, those sole source contracts must be executed prior to graduation, but the agencies were shut down and the firms graduated, and so they couldn't get the contracts executed prior to graduation. And again, SBA tried to help, but they couldn't find a legal mechanism for doing that. So that's what this is designed to create. Then there are two other provisions that pertain to tribal 8As, and the first is that no one individual can be responsible for the management or daily operations of two of those tribal entities at the same time. And I believe that's kind of the practice now, but SBA is putting it in the regulations. And then the next thing is that those tribal entities maintain an exemption from affiliation so that the sister companies are not deemed to be affiliated with each other. And for 8A purposes, they're not affiliated unless the SBA administrator determines that there's a substantial unfair competitive advantage. But that's not been defined, and SBA is now saying, well, in order for us to determine that, we will examine the firm's participation in the relevant NAICS code nationally and compare that to the overall small business share in order to determine whether there's a substantial unfair competitive advantage. So if you're involved with a tribal firm, you definitely will want to take a look at those and think about how you might want to comment on that.
All right, so as Pam said, we intended today to focus on the mentor-protege proposed rule because we'd never done a webinar on that before, and we did do a webinar several weeks back on the limitations on subcontracting rule. So we encourage you to check out that webinar for a full discussion of the limitations on subcontracting rule. And if you're interested in getting our proposed comments, which are due on Monday, email us and we'll send you our limitations on subcontracting comments. Now, in the 10 or so minutes we have left, though, I'm going to suggest let's do a lightning round on the limitations on subcontracting so we can at least flip through some of the slides so we can give you some highlights of what we talked about with SBA yesterday. We're not going to cover all the information on these slides, but there'll be a few things we could pass along. So in terms of the timeline, we just have a confirmation. Comments are due Monday. SBA expects they may be able to get the final rule out later this year. We'll see. I think maybe more likely into next year. The proposal is to keep all the percentages the same in terms of the way that the limitations on subcontracting work right now, but of course there's going to be a shift from the percentage of labor cost to the total contract value. We discussed yesterday that that really means total funded contract value. So of course if you have a $10 million contract value, but you only ended up getting $5 million of it, your performance requirement would be the funded $5 million amount. The sub-bullet here underneath the 50% for supplies, that's a critical point. And SBA indicated it may have been an oversight that that was left out of the proposed rule because the statute provides for an exclusion for the cost of materials on supply contracts, but that's not in the proposed rule. So we're going to make sure we address that in the comments, and I think we're optimistic that the SBA will put that into the final rule. On mixed supply and services contracts, there's been a lot of, I think, hand-wringing over what the proposal means for mixed, well, now that we're shifting from labor cost to total contract value, what does it mean for services contracts that also include some supplies? Does the small business have to perform 50% of the total amount, which would include maybe a lot of supplies that would have otherwise been provided by a large business? And the SBA confirmed yesterday that the proposal is you look at what is the predominant requirement for the contract. Is it a services contract or supply contract predominantly? That's the NAICS code that will be assigned then, either a services NAICS or a supply NAICS. And then it's whatever NAICS code is applied, that's going to tell us which performance requirement applies, either the services performance requirement or the supply performance requirement. And we are only going to apply the performance requirement to the applicable portion of the contract. And what I mean by that is demonstrated in this next example that the SBA gave, that this is predominantly, it's a $3 million contract predominantly for supply, $2.5 million supply, $500,000 services. This is the example in the SBA's proposed rule right now. And it says that we're going to apply the 50% performance requirement to the $2.5 million. We're not applying it to the entire $3 million. And we said yesterday, you know, it would be helpful if the SBA would provide a second example in the rule that just flips the scenario. So we're talking about $2.5 million of services with $500,000 of supplies. And SBA seems very willing to give us a second example just to make it absolutely clear how we handle these types of mixed contracts. Construction is really critical for us to get a lot of comments in on construction because the SBA, the way that the construction performance requirements currently work, there is an exclusion for the cost of supplies or materials. In the proposed rule, they've not included that exclusion. So the percentages have stayed the same, 15 and 25%, depending on the type of construction project. From what we've heard from a lot of companies in the construction industry is that those percentages are going to be unworkable for small businesses if they have to include the cost of supplies and materials in the total contract value. SBA is open to comments on this, and they're telling us, show us where we have the flexibility under the statute to include this exemption, to make it more workable. And we think they do have the flexibility because the law, the 2013 NDAA, really gives them an open book, or I should say a blank check on construction, because the law just says SBA will decide in regulation what to do about construction. So we think that that they have the flexibility to keep the exclusion, and the law provides a similar exclusion for supply contracts, so why not for construction projects as well?
So the other part of the NDAA was that similarly situated firms can team together without the necessity of establishing a joint venture, and that those teaming partners combined could satisfy the new limitation on subcontracting, which of course is a good idea, but there are some strings attached in this proposed rule that we think are problematic. First of all, the similarly situated firms must be identical in terms of if you're participating in a hub zone set aside, it must be 2 or more hub zone companies that are similarly situated. Women to women, SDVOSBs to SDVOSBs, and you can't mix those groups. Obviously, if it's a small business set aside, any of those socioeconomic classes can team together so long as they're small under that primary NAICS code. But SBA is requiring a written small business teaming agreement, and so it must be in writing, and then they're requiring that compliance is an element of responsibility and not a component of size eligibility. They're asking the prime small business contractor to certify compliance, and that certification is supposed to be at the contract level. We have a concern about that because if it's a multiple award contract or an IDIQ contract and you're certifying compliance up front and maybe don't even know the extent of the work, you should be at least certifying on the task order level. We're suggesting this should be treated more like SBA and the agencies treat their large business prime contractors, and say that, you know, you have to put in the good faith efforts and not ask for all of these certifications, but, you know, make the standard a little bit more workable, because again, in some situations it will be very difficult to know at the outset how you will comply.
Wanted to also add here, the SBA indicated yesterday that they recognize some contracts require more work up front, so that it may not be possible. If you're doing this, you see here the year-by-year determination of compliance, base year and then each option period. It may be if you're doing a lot of the work up front that the SBA should look at the performance spread out over multiple years in order to give a fairer and truer picture of compliance. So that's something I think we should comment on as well. And in the 1 minute or so we have left, I just want to comment quickly on a couple other issues. Affiliation based on economic dependence. This is one where the SBA is proposing to write into their rules that if you have 70% or more of your revenue during the prior fiscal year on contracts with one company, you are economically dependent and therefore affiliated with that company. And the SBA seemed open to the suggestion that they look at the most recently completed 3 fiscal years as opposed to 1 year, and they really want to get our suggestions on what other factors should be considered in rebutting this type of affiliation. They're proposing that if you're a startup or if you've only received a few contracts, that would be a factor in rebutting this type of affiliation. But there are other things, like maybe a trend that maybe you used to have a significant percentage of your revenue a few years ago, but you're trending away from that company, that they ought to consider that as well. And so we'd like to get everybody's feedback in the few days we have left before these comments are due on what other suggestions we could make here.
John, I think that's what we have. That's all we have time for. Again, if you want more information on this proposed rule, we encourage you to listen to the previous webinar, and we continue to encourage you to send comments to SBA on both of these rules. And don't forget to tell them what you like as well as what you don't like about the rules. And then finally, if you would like a copy of our proposed comments on the Mentor-Protégé program. We'll get them out as soon as they're ready, and we will send you a copy of these slides after this presentation concludes. So thank you very much. We hope you found this to be useful. Bye.